Calling the meeting to order of the Standing Committee on Transport, Infrastructure and Communities, 42nd Parliament, first session, meeting number 72. Pursuant to the order of reference of Wednesday, September 20th, 2017, Bill S2, an act to amend the Motor Vehicle Safety Act and to make a consequential amendment to another act. And we have with us today appearing the Honourable Marc Garneau, Minister of Transport, and as witnesses, Department of Transport, Donald Russell, Associate Assistant Deputy Minister, and Kim Benjamin, Director General. So to all of you, I welcome you. I'd like to also welcome our newest officially, Ben Lobb, and of course Michael Chong, and we're happy to have Kelly Blackblock back here on our team, as well as Mr. Aban. And the group on this side we all know very well. So, Minister Garneau, I will turn the floor over to you.
Thank you, Madam Chair, and I will apologize ahead of time if I begin to cough on occasion. I'm nursing a cold at the moment, but hopefully it won't happen. Madame la Présidente, j'ai l'honneur.
Madam Chair, I'm pleased to be here again, this time to speak about Bill S2, the Strengthening Motor Vehicle Safety for Canadians Act. This bill is a key component in support of the transportation safety theme set out in my vision for the future of transportation in Canada, Transportation 2030, and it also fulfills our government's commitment to strengthen the Motor Vehicle Safety Act, to make our regulatory framework more flexible, to promote innovation and support the adoption of new technologies while still protecting the safety of Canadians. A key objective of this bill is to strengthen the recall order powers. In 2014, the Act was amended to provide the Minister of Transport with the necessary powers to order a company to issue a notice of defect. And this power has been used 3 times since 2014 to protect Canadians, but there's still a gap in the application of this power.
Company to issue a notice of defect, there is little that it could do today to protect Canadians if a company were to refuse to issue a recall and to pay for the defects to be corrected. This could mean that the repairs would not be carried out and the defective vehicles would still be on our roads. This new authority to order manufacturers to issue a recall and to correct defective or non-compliant vehicles at their expense would close that gap. I recognize that the recall order powers are powerful tools, which is why this bill includes a recourse mechanism for companies that ensures transparency and accountability. Our goal is to keep our roads safe and protect Canadian consumers. In addition, the proposal for a new power to order a company to undertake testing of its products, which is similar to the power available under the Canadian or the Canada Consumer Protection Safety Act, would be invaluable for defect investigation, particularly where there are proprietary technologies involved. This would assist Transport Canada in carrying out its responsibilities. À propos de nouvelles technologies,
speaking of new technologies, the automated and connected vehicle revolution has arrived, and the provisions proposed in this bill would support industry in bringing these innovative technologies to market. They would allow us to maintain the safety of the vehicles on the road where new technologies are being developed and tested while protecting Canadians. A more efficient exemption process, extension of the period for interim orders, and the new order power to suspend, modify, or adapt a regulation would contribute to our objective of promoting innovation. Improving our investigation and enforcement tools is also key to protecting Canadians. And as such, we've included in the bill an administrative monetary penalty regime and a consent agreement tool. In addition, the inspector powers have been clarified compared to the previous version of the bill to specify the purpose of the inspector's entry onto company property.
House put forward an amendment to the bill to address concerns raised by Canada's vehicle dealers. I am pleased to inform you that we have worked closely with the Canadian Automobile Dealers Association to better understand their views and to clarify how the bill would protect their members. As a result of these conversations, we will be coming forward with a proposed amendment to the current bill that addresses their concerns. Madam Chair, Canadians have been waiting far too long for the improvements in this bill. It has been nearly 2.5 years now since the majority of these provisions were first proposed by the previous government. I hope that your committee will pass this bill swiftly so that all Canadians can benefit from increased safety that these provisions will bring while we continue pursuing other ways to improve safety for Canadians. Thank you, Madam Chair.
Thank you very much, Minister Garneau. On to our questioning. Mr. Lobb for 6 minutes.
Thanks very much. And thanks to the Minister for appearing today under the weather. Appreciate that, for sure. Interim orders. In your presentation, you talk about interim orders, okay, for new technology extensions. Was there any discussion around how long those interim orders can last? Is it months, weeks, years, decades? How long are we talking?
I guess the answer to that would be as long as they're necessary, but no longer than necessary. We, as the title suggests, want to have the flexibility to have, on an interim basis, some flexibility, particularly with respect to the introduction of new technologies, whilst at the same time, of course, being uppermost, it being uppermost in our minds that safety is our main concern when new vehicles are introduced. But we do feel that we need to provide some flexibility, hence these interim orders, but it would only be for the time necessary to allow the necessary use and testing of these vehicles.
So we all know the names out there now that are using highly automated vehicles, Tesla, Volkswagen, all the rest, on and on. Does Transport Canada currently have an idea on a daily basis how many of those vehicles are traveling Canadian highways and roads?
I'll turn to my officials in terms of numbers. The numbers are still very small at this point in time, and certainly there are vehicles that have some degree of autonomy. As you know, there are 5 levels of autonomy, 5 being totally autonomous, don't even need a driver. Some of these are quite advanced in terms of having features that, such as keeping in lanes and adaptive speed control, those kinds of things, and they're getting more sophisticated all the time. And as you pointed out, many companies are introducing new models. I don't have an exact count. I don't know if we have that information. I'll turn to my colleagues, but at this point in time, it's still very, very small because we still need to, as we move towards complete automation, we need to put a lot of infrastructure in place outside of the vehicles, as well as we need to be in a situation where there are more vehicles on the roads that are communicating between each other.
Okay, so that's maybe one we'll have to look at as we go down the road, because I think they're having some significant issues in the United States with tests and tests gone wrong and, you know, exemptions inside there. One question I wanted to ask you, and probably the largest recall, the most serious recall, is likely outside of the Motor Vehicle Safety Act, and it's to do with the Volkswagen diesel engines and the cheating on the tests and so forth. And were there any discussions on that? Because currently, it would be through Environment where these would be flagged, I believe. But I don't believe Environment has the minister there, or you as minister has the ability to recall those issues and force the company to do anything in Canada. So can you comment on that?
Yes, you're right. It's with environment, and this was a decision that was taken, I think, in 1999 to separate environmental issues from safety issues. Yes, we've all followed the Volkswagen diesel saga, very sad saga, but it is not a safety-related issue. It is certainly a serious environmental issue, but that is now the responsibility of
So I'm just wondering, in a time where we say,
environment.
you know, a bill that is presented to the House of Commons through the Senate, you know, the biggest feature in it is the theory or the idea of recall, and it probably the biggest issue in the last 10 years. There was no work in collaboration with the other department through you to make sure that an issue that maybe it isn't safety, but certainly the environment is at the forefront of everybody's mind, that there's nothing here for Canadians on that.
Yeah, and again, it's because the Motor Vehicle Safety Act, as the name implies, is concerned with safety.
Yeah.
The fact that we have to make sure that any new vehicle introduced on our roads is safe for people to drive. Other issues that are non-safety related sometimes come under other departments. I would say to you that there are big safety. The Takata airbag is probably an issue that has grabbed a great deal of attention, and there are smaller issues with individual models.
Okay, one final thought was with the vacuum brake in the Ford F-150. That was an issue earlier in the year in 2016 that you dealt with. You're talking about transparency on these decisions and versus what Transport Canada's findings are versus what Ford's information is to counter it. And I know you guys came to an agreement anyhow, but how much is the public as a consumer are we going to be able to see that decision and how it comes to be under the change?
And there's an example of where we decided that since the manufacturer was not ready to recall the vehicle, but we felt that there were safety concerns, but didn't have the tools. We don't have the tools of S2. We exerted pressure as we could in discussions with them, and it certainly also received quite a bit of media coverage, and eventually Ford decided that it was a good idea to actually proceed with a recall. So the new powers of S2 will allow us to solve those kinds of problems. And I hasten to add, hopefully they won't be used very often. Most of the time, manufacturers not only announce a defect, but they also proceed with the other steps. So hopefully most of the time, there will not be a need to invoke the powers that Bill S2 provides.
Thank you very much. On to Mr. Fraser for 6 minutes.
Thank you very much, Madam Chair. And thank you to the Minister for being here. I appreciate your presence to discuss this important piece of safety legislation. When I was doing some review of Bill S2 before it was last on the floor of the House of Commons, I came across an article indicating that as many as 1 in 6 cars on Canadian roads today might be subject to an outstanding recall. This blew me away, quite frankly. I don't think Canadians appreciate how many cars are actually subject to a current voluntary recall. Right now, there's not a power for you or whoever the minister may be in the future to order it or to prevent the sale from a dealer's lot to get on the roads. With such a low understanding of the number of recalls that are out there, how can we make sure that when you use this power, should you have to, and I hope you don't, but should you have to, how are we going to ensure compliance? Can you point perhaps to how the administrative monetary penalty is going to lead to a high completion rate of repair when it comes to really making a difference for the safety of Canadians?
Well, thank you for your question. You really touched on two sides of the equation. We want to make sure that manufacturers do issue recalls, which they do presently, but then also or the issue a notice of defect, but that we want to make sure they also follow up with the recall and the repair. And that's what S2 is in part meant to do. And if they don't, there are different tools. At the moment, the only tool we have is to take them to court. We want to have a graduated capability with administrative monetary penalties or consent agreements, which don't take us as far as pursuing for many years going to court. So that's a new element in this bill. On the other side of the coin, many drivers are notified that they have a defect by the by the manufacturer, But sometimes, regretfully, they decide, oh, my car's 7 years old, I'm not going to bother. So there is also, I think, there's not an educational component in the Motor Vehicle Safety Act, but it is certainly important. We hope that with this new act, people will be more conscious of the fact that even though their car is older, that it should have defects, especially if they are safety related. But that also demands an initiative on the part of car owners.
So just maybe this is outside the scope of the four corners of Bill S2, but you mentioned public education. In addition to the inevitable media coverage that a piece of legislation gets when it goes through the legislative process, is there plans as part of the Transportation 2030 strategy to engage in a public education and awareness piece, or are you confident that with the enforcement mechanism in there, the public won't need to be educated because it's going to happen as between the government, dealers, and manufacturers?
I think this bill will help quite a bit, but I don't rule out the possibility of taking other measures to really, for safety reasons, encourage drivers to be more conscientious about fixing cars, and this becomes particularly important also as well if they eventually want to sell their car and
Certainly.
And they don't want to sell a car with multiple defects.
Of course. On the issue of automated vehicles, we heard through a previous study on smart cities that this is coming in short order. 10, 15 years, they're going to be everywhere, we heard. This was a bit of an eye-opener for me. Coming from rural Nova Scotia, to picture driverless vehicles on the roads is a long shot, really, for most people to imagine. Knowing that we're sort of on the precipice of this new technological development, how is the exemption power going to both ensure that we're on the cutting edge of technology so the economic benefits come to our country without jeopardizing the safety of Canadians as new technology makes its way onto the roads?
So it's a very good question, and it's a fine line because what we want to do, and by the way, it will be incremental. It's not as though, after a certain period of time, suddenly 100% of our vehicles will be automated vehicles. The manufacturers are developing vehicles that have more and more autonomy, but that are still driven by people. And in the meantime, there are, and this is something we're encouraging, Ontario is out there already doing it, is that there are tests in specific places. For example, the town of Stratford, Ontario, is actually accepting, the development of driverless vehicle technology to be done on the test site of part of the town. Other countries are doing this in the United States and Europe. We hope other provinces will become involved. We're very encouraged by the Active and Aurora programs, which are at Edmonton University and the University of British Columbia. But as the vehicles are put out there in real life situations, we have to ensure that they remain safe and do not present a hazard, but we have to make some adjustments to the regulations because we're dealing with new technologies. It's very much something in front of us at the moment, but we wanted to give ourselves the flexibility in Bill S2 so that we could do this, so that we could encourage the innovation and the development.
Certainly. Thank you.
Monsieur Aubin.
Thank you, Madam Chair, and welcome, Mr. Minister. I have to admit that seeing you twice in 3 weeks, well, keep it up. We love seeing you here before the committee and love asking you questions directly. First question, very simple. We've often talked about a bill which aims to align our legislation with American legislation. But when I look at this, and correct me if I'm wrong, this alignment seems more like catching up with the U.S. Is in Bill S2 an element where we are ahead of the Americans and where we are leaders ahead of the U.S.? Well, we're working very hard to catch up in light of the fast evolution of technology, not necessarily compared to the Americans. Technologies are evolving quickly everywhere. So clearly, we have to work with our American partners, and this is something we are doing in every area of transportation, be it vehicles, trains, or airplanes. There is a council. In English, it's the
Council qui existe entre nos deux pays depuis très longtemps.
which has been in existence for many years. And the purpose of this council is to harmonize U.S. and Canadian regulations so that when you're driving a car and you cross the border, the rules will not change when you're in another country. Are we ahead of Americans in other areas? Well, I would have to turn to my colleagues to address that. But let me assure you that we certainly are aware that we have to move as quickly as possible. Thank you. I'd like to draw your attention to Section 9 of the Motor Vehicle Safety Act, which gives you the power to exempt certain vehicles from safety standards when this would encourage the development of technology. So for ordinary people like myself, I understood that there would be an exemption when technological innovation would improve safety. I imagine that's the spirit of the Act. Would you have a concrete example to illustrate that? And how do you justify this new power of exemption without first having addressed the weaknesses in the Auditor General's report when it comes to inspections? The Auditor General had some very specific things to say about inspections. I know that Bill S2 is not a response to the Auditor General's report, but I think that we need to put all the facts on the table here. Well, I cannot give you a specific example with regard to the exemption because that is not allowed so far, but as soon as S2 is passed, we will surely be able to give you some examples. The potential of autonomous vehicle is that they will be safer, but before they're allowed on our roads, we need to validate these technologies, and they will surely have, and adjustments will surely have to be made in regulations to help that, and so regulations will have flexibility to ensure that safety can always be improved. As for the Auditor General and his remarks, we received his report, and in fact, it was studied by another committee, Public Accounts, and Public Accounts made recommendations to us. We are actually we're actually just working on our response to that report, and we will present our responses shortly in the House of Commons. Clearly, we always take the recommendations of the various committees, including this one, very seriously. So without revealing anything at this point, please believe that we take all of this feedback to heart. Clearly, S2 is not a response to the Auditor General's concerns. These are two issues that work in parallel to each other. But if there's anything we at Transport Canada can improve, especially in matters of safety, we will do so. In sections 12 to 14 of the bill, the inspectors of Transport Canada receive more powers, including the power to ensure all vehicles are compliant, the power to collect data on collisions. And as human resources will increase in the department, the fact remains that over the last few years, fewer data have been generated, in part by cutting resources by 59% to collision information. So how will the government fulfill the requirements in S2 if resources have been cut? Well, risk management procedures were cut back. I don't think that was the right decision. In the past, inspections were carried out because they had always been carried out a certain way, but we never really questioned why inspections were being done the way they were. And they were very labor-intensive, yet it wasn't necessarily the best way to spend time or resources. So Our approach was to focus on risk management. That's our main criteria, which determines where we will focus our inspections. I believe it's a better approach. Certainly, inspectors will receive more powers under this bill. When it comes to safety inspections, if there is a suspected defect, we have worked with vehicle manufacturers. Our approach was open, and there were frank exchanges. Exclusif.
Privilégiée.
If proprietary technologies are at stake, however, we must ask manufacturers to provide us with the results of their tests, and we can specify which tests these are. Thank you, Madam Chair, and thank you, Mr. Minister, for being here today. We know that the bill follows former Bill C-62, which died on the order paper in 2015, so that bill was never passed. Can you tell us what the main differences are between S2 and C-62 and the improvements contained in the bill we are studying today? Certainly. As you rightly said, perhaps, well, it's hard to measure. I would say 75% of the bill replicates the 2015 Conservative bill. And then there was the election, so the former bill died on the order paper. What's new in S2 is the power to negotiate consensual agreements with vehicle manufacturers and to conclude administrative agreements. This means giving us powers to penalize manufacturers without necessarily taking them to court, which would be a lengthy and costly process. So we are giving ourselves greater flexibility in terms of the action we can take if we are not satisfied that car manufacturers have done what they had to do to rectify a situation involving a defect. We're also extending orders and widening their scope, as well as a decree for dispense. This comes back to increased flexibility. If technologies evolve so quickly that regulations need to keep up, we want our regulations to be flexible enough to allow new technologies to prove themselves, so regulations can be updated without affecting safety. So there have been a few new changes in Bill S2 which have come on top of Bill C-62. Thank you. What are the key elements in Bill S2 which allow us to say that the safety of vehicle passengers will be reinforced? Well, the main thing is that the minister will have more powers if that power needs to be applied. In other words, the minister will be able to order a recall if defects have come to light and can order the manufacturer to fix those defects at the manufacturer's expense. I think this will inspire much more confidence in consumers. So not only will a notice of defect be issued, but a notice of repairing these defects. The defects will have to be fixed by auto dealers. I think this is good news. That being said, this is something we can do, but which we are not obliged to do, because most often, manufacturers will admit that there is a defect, and they themselves will voluntarily issue a recall notice and fix the problem at their own expense. To your knowledge, has a vehicle manufacturer ever not issued a recall notice or has hesitated to do so? Yes, in my speech, I mentioned that there were 3 incidents where, in our view, the manufacturer did not recognize vehicle defects. Ms. Kim Benjamin can speak to that example, but you've raised an important issue. We want to minimize the delay for defects to be fixed. Sometimes when a defect comes to light, there's no quick solution, and a manufacturer has to come up with a solution. The manufacturer has to quickly produce a certain number of parts in a short period of time, but we don't want the solution to be dragged out, especially when cars with defects are on the roads.
Had to step in.
Okay, so we have had 3 examples since we received the power to order a notice of defect where we've had manufacturers who were not in agreement with us. For each of these cases, we started the process with the preliminary determination, which is the public announcement. The information is given to the public at the same time to the manufacturer. In each of these instances, the manufacturer decided to issue the notice of defects, or in one case, it was a consumer campaign to essentially conduct the repair in advance of us having to make the final order for a notice of defect. So we've posted each of these on our website, and like I said, because of the pressure that has come from the public being aware, the public giving us information, we haven't had to proceed to the final notice of defect. They've done it on their own.
Thank you very much. Mr. Hardy.
Thank you, Madam Chair. I'll be splitting my time with Honourable Member Hunter Tutu. Thank you for being here, Mr. Minister. Summertime has arrived late, and the summer cold has got to be just about the worst.
Not fun.
I wanted to talk about the administrative monetary penalties, and I understand that under certain circumstances there could also be imprisonment involved if somebody doesn't comply. Can you describe how that could all come about? Is that the case?
An administrative monetary penalty is actually not the criminal penalty. The whole idea is that it is administrative. It doesn't have the same burden of proof to be able to demonstrate the non-compliance, and it is meant to be a way of bringing someone into compliance that is not as much of a punitive measure as a criminal prosecution would be.
So under what circumstances would a criminal prosecution take place?
Where we felt that the issue was far too egregious to be dealt with on an administrative basis.
I see. In a meeting with the Manufacturers Association representatives, they were somewhat concerned that they could be facing criminal charges when, in fact, the action was by a dealer. So they wholesale the vehicle to the dealer, and then it's up to the dealer to withhold that from the public, certainly not the manufacturer. Can you speak to that concern?
Well, certainly it would not be our intention to penalize the wrong party in a situation like that. So we'd have to look at the details. And I would say that, the criminal pursuit is a very serious matter and would only occur under certain specific instances where there was a sense, where there was clear proof that there was something deliberately done. And so the burden of proof in a situation like that is quite high, but it's also a situation that I think would be rather exceptional. But administrative penalties are quite common in Transport Canada, in other areas, for example, railways and ships. When there are violations, it is a tool that we have, but we didn't have in this case, and we think that this is part of a graduated response capability.
Great, thank you. I'll turn the rest of my time over to Mr. Tutu.
Okay, thank you, Mr. Hardy, and apologize for being late. Not very often I run into a constituent in the lobby of the office building, so I had to say hello and entertain her for a few minutes before she went to another meeting. I would like to welcome you, Minister Garneau, and hope you had a good summer.
Thank you.
I guess the question, I only have one question on this, and it's an issue that's been brought up a couple of times this summer in Iqaluit. As you know, Nunavut is quite different from the rest of the country, where we don't have dealerships. And I know of one case where there was a recall ordered for a vehicle, and another case where there was a warranty thing that they fixing automatically on their own, the dealer. But because there's no dealer there, and they're saying it has to be an authorized dealer of the vehicle that has to do the work, they're being told that they have to put their vehicle on the ship it out, get the work done down here, and then wait till next year to get it back. So I'm just wondering if there's anything in here that could help address that concerns, where we force dealers to utilize, because we do have garages in the communities up there, but they're not authorized dealers, but they do have licensed mechanics to be able to address that, so that work can get done, so that people that can't be without a vehicle and have to pay for the shipping of that vehicle down south to get fixed and back, they're just using those vehicles still with those defects, and there's no opportunity to change that. So I'm just wondering if there's something in here to help address that issue. Thank you, Madam Chair.
Thank you. You're reminding me that things are very different in the north, and there are challenges that we don't even dream of down here because of different circumstances and not all that infrastructure being in place. The Bill S2 is essentially focused on saying that if there's a defect in a vehicle that somebody's driving in Iqaluit or somewhere else, that ultimately, if the manufacturer doesn't fix it, then, and we feel that it is a safety hazard, we can force them to fix it at the manufacturer's cost. But you're bringing in an element here that is different from the normal situation, that is shipping it from Iqaluit or some other to a southern location. There are other alternatives as well. They can ship a new car up that's without the defect and do a switch. Those things, but I would have to get back to you on the particular circumstances that exist up there, where there isn't that the kinds of things that we take for granted down here.
Okay.
Thank you very much. Sorry, your time is up. Ms. Block.
Thank you very much, Madam Chair, and I too want to thank you for joining us today, Minister, and welcome to your departmental officials as well. I too am suffering from a summer cold, but not to the degree that you are, but you'll hear it in my voice. The Auditor General's fall 2016 report stated that overall we found that Transport Canada did not develop motor vehicle safety standards to respond to emerging risks and issues in a timely manner. It went on to say we could not always determine how the department used evidence and research to develop or amend safety standards. In the case of Bill S2, this bill would give the minister and his or her department significant new powers, and I'm wondering if you could tell us what, if any, attempts have been made to resolve some of those issues that have been raised by the Auditor General.
Yes, and I don't have at the top of my mind the years that were being covered by the Auditor General's report, and certainly the Auditor General's report we have looked at, and we take that report very seriously, and as I say, we will be responding through the Public Accounts Committee to the recommendations that were made to address the issues brought up by the Auditor General, and yes, there are some things that we can do better on, and we will be taking that very seriously. I understand that the Auditor General did find some things that we were doing well, and so that's good news. Our ability to identify vehicle safety defects, which is fairly crucial in this whole thing. As part of ensuring when it's not necessarily brought to us by the manufacturer that we're keeping on top of it to identify defects that are out there. But I think that I can't tell you exactly what will be tabled in Parliament fairly soon, but it will be our response to the Public Accounts Committee's study of the Auditor General's report. And I think that perhaps at that point, if there are questions that you feel that still need to be asked, I would welcome them.
Thank you very much. I do want to speak to another measure in S2 increases the power of Transport Canada inspectors to visit facilities and compel documents and testimony from employees in order to demonstrate compliance. And I guess my question would be, what would trigger a visit by Transport Canada for a company to demonstrate compliance because this isn't based on complaints, it's just that they can go in and ask for this information. So what would trigger a visit by Transport Canada?
I think probably the quick answer is exceptional circumstances, and hopefully these are powers that would not be necessary. But as I say, from our point of view at Transport Canada, what we want to make sure of is that the whole process of ensuring that cars are safe, or actually goes from motorcycles to trucks, and if we are experiencing a lack of information being provided to us so that we feel is necessary in order to understand anything related to addressing a defect, then we are giving ourselves that power to do it. And as I say, I think it would be in exceptional circumstances. I'm very confident that we will have very few situations where that kind of ministerial power or inspector power will be invoked, because I think that we will work well with the manufacturing sector, but we're giving ourselves that flexibility should it be necessary.
Thank you. Do I have 2 minutes? Great.
Almost.
Almost, okay. I did want to ask about the fact that this bill was introduced into the Senate. And that question was asked a fair bit during the debate in the House of Commons of all members who may not have the answer to that question. And so with you here at the table, would you be able or willing to answer why this piece of legislation came to the House of Commons through the Senate?
Yes, with pleasure, and it's not very complicated. This was a bill that we wanted to put into the system very quickly in the early days. And as you know, when a new parliament starts, there's kind of a blank slate in both houses in terms of what kind of legislation is going to be put forward. And we decided as a government that the Senate, which, as you know, can take a bill from the government and pass it through there. It doesn't have to always start in the House. They were willing to begin looking at Bill S2, one that your government had, in an earlier version, introduced. So it was just one of those situations. There's nothing mysterious about it. It was a question of flow through. There are many bills that new governments introduce, and at this particular point, there was an availability of resources in the Senate just to study this bill.
Thank you.
Thank you very much. Thank you, Ms. Volotka. On to Mr. Secan.
Thank you, Madam Chair. I'd like to actually follow up on my colleague's previous line of questioning, and perhaps just take a step back, because I was actually really surprised to hear that your office and you, the minister, didn't have these powers before. So I'm happy to hear that S2 is coming forward. But I'd like to know how you envision these powers being exercised, because I'd imagine a situation has deteriorated to the point that you're being forced to act. So are recalls going to be ordered in conjunction with manufacturers, or how is this going to be rolled
I think many Canadians think that at the moment we have the ability in the Government of Canada to order recalls. They are not aware of the fact that the law at the moment only orders a notice of defect to be put out by the manufacturer, but we don't have those. And that's in part because the manufacturers very often follow through, and they proceed with recall and repair, which speaks well for them. But as my colleague Kim Benjamin said, there were a few instances where there was a difference of opinion. Us, from our point of view, from our expertise at Transport Canada, our inspections and what have you, and feedback from the public, felt that there were, in this 3 cases where we weren't hearing from the manufacturer to say, hey, there's a defect. In fact, they disagreed with us. So that's one of the situations where the power of the minister can be invoked. We hope it won't happen very often, but there can be instances. There are so many models out there, and there's so much technology that it's important for us to have that capability if we feel strongly that the defect needs to be addressed.
Thank you. You just mentioned that you weren't hearing from manufacturers, and I guess I don't want to see a situation, keeping Canadian safety top of mind, a situation where you have a foreign company which has cars operating in Canada is perhaps incorporated there, and by virtue of that incorporation, sheltered from legal action. I guess I'd like to know how is S2 going to address those foreign companies operating within our country?
Well, the law is addressing both manufacturers and importers of cars. So we feel that we are addressing any car that's going to be, or vehicle that's going to be on our roads has to be safe, and that includes imported.
Thank you. I'd like to pass over any remaining time I have to Mr. Badaway.
Thank you, Mr. Sakana. Thank you, Madam Chair. With respect to the process, Minister, and I'm quite excited about it because it is taking something that's been long overdue and bringing it up to date. And with that said, it gives a perspective of 2017 in relation to safety. What I'm most interested in, however, is it's also an opportunity to look down the road and take into consideration not only a perspective of 2017, but the possibility of a perspective of 2030 and going well into the future. And I think a lot of that was spoken about earlier in relation to taking into consideration safety under an environment of quickly evolving new technologies. Having said that, and being more proactive versus reactive being defects and responding after the fact, is there an opportunity that we can actually leverage this process to encourage manufacturers to accelerate new technologies in the name of returns on environmental, social, and economic investments, and therefore being more proactive with respect to those new technologies, and of course with that, the safety that can be actually dealt with those new technologies?
If we had a crystal ball now, I think that if we looked at our roads in 2030, which is only 13 years from now, I think we'll all be a little bit surprised at how this disruptive new technology has implanted itself on our roads in the country, and hopefully for the better. I would say to you that my sense from following what's happening with the development of autonomous vehicles is that the business forces are already very actively pushing this. We've all heard of Tesla, but there are many other companies. Audi is another example, but Google and Apple and the big 3 and many European companies, BMW and others, are all scrambling because they want to own as big a part of that market as possible. So I think they're highly motivated. We don't know. We can have a different discussion about the availability of ZEVs, but that's a different discussion. But on autonomous vehicles, I think they are self-motivated, and they are developing these. And of course, they know that they're going to have to come, their success will be that it has to be safe, it has to be cleaner, it has to be, provide all the advantages that we believe will be accessibility, those kinds of things. So I think there's enough motivational forces in place that we don't need to coax them along too much on that.
Thank you very much, Mr. Badaway. On to Mr. Chong.
Thank you. Thank you, Madam Chair. How much time do I have?
You have 5 minutes.
Thank you. Mr. Minister, thank you for coming. You mentioned in your opening remarks that you're going to be proposing amendments to the bill. I assume that's not in the House, but in committee through the Liberal members on committee. Is that correct?
It'll be in committee.
Yeah, sure. And I assume that means then that you're not supportive of the amendment that was made to the bill in the Senate. I think it's section 10.52. Is that also correct?
We have, when that, and we thank the Senate for engaging with the dealers.
But you don't agree with that part of the bill?
What we've done is we've worked with the Canadian dealers of Canada to find something that we feel they are happy with.
But you're not in agreement with what they've proposed as an amendment? What amendment they made to the bill?
No, not as written. And let me explain why. And the reason is because this is a Motor Vehicle Safety Act. It does not get into managing the relationship between dealers and manufacturers. So it's outside the scope of the Motor Vehicle Safety Act. But we have looked to find a way to, I think, make all parties happy, and
that'll be done through...
You will be deciding in your wisdom whether you want to go with that.
Okay, thank you. And on to a different part of the bill. Now, there's section 13.1 of the bill, or I should say section 11 of the bill that amends the Motor Vehicle Safety Act to add section 13.1 to the Act, which allows you as minister to suspend for a period not exceeding 3 years any regulation of the Act. Now, is this intended to allow innovation such as autonomous vehicles to be on our roads? Okay.
Yeah.
And that's good to hear because technology is changing rapidly, and I think we're quite behind as a country on the legislative and regulatory framework for autonomous vehicles. There's cars on the road today that are fully autonomous, and many cars actually are fully capable of autonomous driving but have yet to flip the software switch on. So I think this is something that we need to be seized with because Ontario is a significant auto manufacturer, and we don't want to fall behind other cross-border states in that competition. I know, is it your intention, if this bill becomes law, to review all the regulations under the Motor Vehicle Safety Act and identify any regulations that are incompatible with self-driving autonomous vehicles or self-driving autonomous systems?
Ultimately, we will have to have a standard for all vehicles, all autonomous vehicles. And as different players bring in new vehicles, we will have the flexibility. And this is a very important part of allowing this innovation is that component of this bill.
But is there a time frame on doing that? Because the reason why I ask is that the National Highway Traffic Safety Administration in the United States last September released new guidelines and regulations on autonomous vehicles in the United States, essentially allowing driverless cars. Google's driverless car is now considered acceptable throughout the United States. In fact, they consider the Google's self-driving car to be a driver for the purposes of their legislation and regulation, and that has allowed companies to set up shop there, raise financing, and really pursue fully autonomous systems and fully autonomous cars. But currently in Canada, that would not be allowed. It would not be allowed for a fully autonomous vehicle without a driver to go down our roads, and I think that will put us at a disadvantage. So the industry is wondering when we are going to review all the regulations that are incompatible with these technologies. in order to ensure that we have a regulatory framework that is just as innovative as what we see south of the border and in Europe.
So the regulations that are there now apply to all the conventional cars that are out there, and it's important that those stay there. Now, when new driverless vehicles start to come in, and we want to encourage them to be on our roads and to have the safety, keeping that in mind, we will look at individual regulations as the case arises to make sure that that now what the United States has done and is put out some guidelines.
Sure.
There's quite a difference between guidelines and regulations. We want to, in Canada, encourage the development. Ontario, as you point out, is particularly involved in the automotive industry, and there's a lot happening. But there's also at the University of Edmonton a program called Active. There's a program in British Columbia called Aurora. We want to get more vehicles out there, and we will be looking at that flexibility in the regulations to encourage them to do exactly what you've described.
Well, just a final. Thank you very much, Minister.
Sorry, Mr. Chong. Mr. Alban.
Monsieur le ministre, si vous le permettez, revenir.
Thank you, Madam Chair. Mr. Minister, I'd like to come back to an answer you gave in the first round. You said that management had changed, and now your approach is based on risk management. If that is to be effective, you have to have evidence. What happened to the 6 regional teams whose mandate was to consult police forces, to conduct inspections, and to collect evidence, hard data? Will those 6 regional teams be brought back if you are to adopt a risk management approach? Well, we're continually adjusting our processes, but the reality is that, as I said earlier, this will evolve. And again, we will base our approach on risk management. In the past, for logical reasons, when it came to aircraft or any other type of transportation, we decided that twice a year we would inspect these ways of transportation, and year after year nothing changed because we simply assessed something that contained a very low level of risk. And then we said, well, that doesn't make sense to use our resources in that manner. We have to use them in a smarter way. And that's what we're doing now. But we're changing over time. We're evolving. We're keeping our eye on the situation. If, for instance, we saw that we needed to adjust our processes, if we had to apply more resources in one area, we would do that. But I think this approach is pragmatic. It's a good way of using resources because our resources are finite. Do you think that the Transport Committee could receive the list of organizations and groups consulted when S2 was being drafted? Because when I compare this with another thing contained in the Auditor General's audit, in fact, he seemed to say that in previous consultations, the vehicle industry was very consulted, but consumer protection groups were not consulted as much, or police forces, or the CAA even. These groups were not consulted as much as the car manufacturers were. And those other groups are also concerned by these issues. And those groups said that the regulations might be biased in favor, or the bill might be biased in favor of the car industry. So is there any way for our committee to see who was consulted? Certainly we have that information, and we'd be happy to share it with you. You mentioned the CAA. They, in fact, reacted to the bill, and they liked it. But sure, we will give you that information. The group of organizations we consulted when we drafted S2. Thank you.
Minister Garneau. Thank you very much for coming this afternoon. I know you can certainly tell. I hope you haven't infected all of the committee and the everyone else in here, because we have a piece of legislation coming up that we need to deal with. So thank you very much for coming. I will suspend momentarily for our other witnesses.
I hope I've infected you with my enthusiasm for it.
Only enthusiasm, no germs. Thank you. We'll continue on our study of S2. Our witnesses, if everybody could take the conversations outside, please. We have with us from the Office of the Auditor General, Michael Ferguson, Auditor General of Canada, with Richard Dominique and Don Campbell. Mr. Ferguson, especially, welcome. It'd be nice to see you back again. And so we'll turn and open up the floor for you. Please go ahead.
Thank you. Madam Chair, thank you for this opportunity to present the results of our audit on the oversight of passenger vehicle safety by Transport Canada. Joining me at the table are Richard Domingue and Don Campbell, who were responsible for the audit. Vehicle safety technology is evolving faster than regulations and standards. Transport Canada faces challenges in exercising its important role of keeping passenger vehicles safe. An up-to-date regulatory framework and the proper oversight of passenger vehicle safety help to ensure that Canadians are driving the safest vehicles possible. We examined whether Transport Canada's regulatory framework and its oversight of vehicle safety defects and recalls were adequate to respond to emerging safety risks and issues in a timely manner. We noted a number of significant deficiencies in the regulatory framework, including a lack of timeliness, an absence of broad stakeholder consultation, and outdated regulations. Nous avons constaté que
We found that Transport Canada did not develop motor vehicle safety standards to respond to emerging risks and issues in a timely manner. For example, Transport Canada's regulations did not allow vehicles to be equipped with advanced headlights that are controlled by software. At the same time, however, vehicles partially controlled by unregulated software are already on Canadian roads. We found that, in general, Transport Canada waited for the National Highway Traffic Safety Administration in the U.S. to develop new or amended standards before proposing regulatory actions in Canada. This reactive approach created significant delays in implementing new standards and meant that some passenger vehicles were not equipped with the newest safety features available in other countries, such as the aforementioned advanced headlamps. There were lengthy delays, sometimes of more than 10 years, from the time that Transport Canada started to work on an issue to the implementation of new or amended standards. Prior to making proposed regulations public in the Canada Gazette, Transport Canada consulted with manufacturers but did not engage broadly with stakeholders such as consumer associations, medical associations, and police. Therefore, manufacturers may have exercised disproportionate influence on regulatory decision-making. We found that some important standards were not working as intended or were outdated. For example, Transport Canada was aware that child seat anchorages could fail under certain conditions, but it had not proposed a new regulation or issued an advisory by the audit completion date. The department stated that introducing a unique to Canada requirement for anchorage strength in passenger vehicles would be detrimental to trade.
Transport Canada did not plan or fund its research and regulatory activities for the longer term. As a result, the department could not prioritize resources and spending decisions accordingly. Finally, we looked at Transport Canada's oversight and analysis of public complaints and manufacturers' recalls. Overall, we found that the department adequately assessed complaints from the public to identify vehicle safety defects. However, the department did not request information about critical safety issues that manufacturers were investigating. As well, manufacturers issued 318 recalls between 2010 and 2015 for safety-related issues that were not brought to the department's attention. Furthermore, the department did not have the authority to assess whether manufacturers implemented effective processes for identifying and reporting safety defects. This limited the department's ability to investigate defects and better protect Canadians. We found that Transport Canada adequately assessed vehicle manufacturers' efforts to complete safety recalls. However, manufacturers had difficulty identifying and contacting owners for some recalled passenger vehicles, especially for owners with older vehicles. Transport Canada has agreed with our 7 recommendations and has prepared a detailed action plan. Madame la Présidente, je termine ainsi ma
Madam Chair, this concludes my opening statement, and we'd be pleased to answer any questions the committee may have. Thank you.
On for 6 minutes, Mr. Lobb.
Thanks very much. The first question I have is the 6th point you made in your presentation, and it was the comment about the National Highway Traffic Safety Administration, the U.S., versus Transport Canada. So how do you see that relationship working then with Transport Canada?
Well, I think, Madam Chair, that in the audit, we actually refer to the department in a number of regulatory cases taking sort of a reactive approach to setting regulations. So waiting to see, for example, what regulations the U.S. set before Canada sets its regulations. And what we are concerned about is, in a number of cases, Transport Canada has perhaps research information or its own research into a certain issue. So, you know, we certainly understand the need to understand what is going on with regulation in the U.S., but I think, you know, Transport Canada needs to be quite clear on, you know, how much of its approach is about reacting to what the U.S. does in regulation and how much of its approach is about, you know, the Canada setting its own regulations.
So is it your opinion then that Transport Canada and the Safety Administration in the U.S., does Transport Canada have the ability to be privy to where they're leaning towards in new regulations for safety for motor vehicles, or is Transport Canada kind of left in the dark until after they've made their decisions?
Thank you, Mr. Chair, Madam Chair. In this case, as Mr. Garneau referred earlier in his testimony, there is the Regulatory Cooperation Committee, Council, sorry, the RCC, and through that committee there is discussion of upcoming regulatory initiatives that could be undertaken by both Canada and the U.S. What we found in the audit is that the work plan set up by the RCC is rather prescriptive in terms of what will be acceptable in terms of new regulation that can be introduced. So, for example, we give the example of the anchorage system for child seat, the child seat restraint system, and we notice in the report that the anchors are failing under certain conditions. Transport Canada could introduce a new regulation, but for all sorts of reasons, one of them mentioned in the report, which is detrimental to trade, they decided not to introduce a made-in-Canada solution to that problem. So there is that cooperation, but to the extent to which might be detrimental to the introduction of Canadian regulation when needed.
The delay, so maybe some little bit of slowness within the department. So when the U.S. is, you have your regulatory council, maybe the U.S. makes a decision, they're working with the manufacturers, they go a certain direction. On average, how long does it take Transport Canada to implement, or is it seamless?
Well, I think, you know, we've identified in the audit that in a number of cases it will take Transport Canada about 10 years to actually make a change to regulations. So, you know, from the time they originally undertake to look at something and do the research and, you know, do their consultations, which again were primarily with the industry, you know, and go through all of that process. I think we've given about 3 examples of different changes to regulations that were taking, you know, 10 years or more to make. So, you know, again, our concern is vehicle technology is changing much faster than that. So a regulatory system that takes 10 years to put new regulations in place doesn't keep up with the pace of change in the technology.
Okay, maybe one chance for one last quick question here. 10.10 you made in your presentation, 318 recalls between 2010 and 2015. Of those 318, were you able to identify a hypothetical scenario where if this new bill was brought forward as to where the minister should have or would have the ability or would be proper to interject and force a recall?
Madam Chair, I mean, we haven't done that type of, mapping to what's proposed in the bill. I guess as auditors, really what we do is, we did an audit on a particular topic. We found a number of places where there needs to be improvements. We made some recommendations. The department may feel that, some of those recommendations can be dealt with by changes to the legislation. As auditors, I guess, our approach is always, we'll wait and see. And probably at some point we'll go back and we'll do a follow-up and we'll see whether the department is having more success at being able to access information about what the manufacturers are aware of and are investigating.
Mr. Badaway.
Thank you, Madam Chair. I think, although opposite sides of the table, I think we have the same sort of vision or the same direction that we're actually leading to, especially with Mr. Chong's comments earlier with the minister, looking down the road and utilizing this process as somewhat a leverage or a lever to be more proactive. And that's what I want to address. Do you feel that there is an opportunity to take what you've done, and I might add, it's been very in-depth, to encourage the development of an enhanced auto economy by way of incentives leading into the future, somewhat anticipating, I guess, what those new technologies will be. As I spoke about earlier with Minister Garneau, do you feel that there's an opportunity here to encourage new technology through innovation that will, one, develop proactive, not reactive based on defects, but proactive returns on environmental, economic, and social investments? And two, do you feel it will encourage new and improved product produced right here in Canada to strengthen, obviously, our overall GDP, but most importantly, to take that next step, to fulfill the vision of how we deal with being proactive on dealing with the possibility of future defects or environmental defects or social, and of course, ultimately leading to economic growth?
Madam Chair, throughout the audit, again, I think one of the main points that kept coming out was this issue of regulations not keeping pace with technology. And in fact, in some instances, like some of the lighting systems that exist now in vehicles in Europe that are innovative but are not allowed under Canadian regulation. So when you look at things like, lighting systems being that closely regulated, but some of the intelligence in semi-autonomous or autonomous vehicles not being under regulation, I think our concern is that there's a mismatch between the regulatory and the pace of technology. And I think that, from an economic point of view, certainly becomes a drag on economic activity if regulations are not keeping up and are prohibiting certain technologies that have been proven elsewhere as having safety benefits. So I think really, from an economic point of view, you want to make sure that the regulatory system matches the pace of the industry, and that will allow the right technologies, that will allow the right innovation, and that will make sure that the regulatory system is not a hindrance to economic activity.
Great. That's good news, because we see this as not being a bill and/or a process that will simply sit on the shelf and it's done. No, it has to breathe. It has to move well into the future, so hopefully the regulatory process can keep up with the pace of technology. So I appreciate that answer. A point you made, Transport Canada has agreed within our 7 recommendations and has prepared a detailed action plan. With respect to the audit itself, 2016 fall reports to the Auditor General of Canada, what year did you actually go back to with respect to the concerns that you brought forward within your audit? What years did it actually cover?
So I'm just double checking here to make sure that I get it exactly right. So the period of the audit was from January 2010 to September 2016.
Okay. And Transport Canada has agreed with all 7 recommendations and has prepared a detailed action plan?
They agreed with the recommendations, and they prepared an action plan that would have been presented to the Public Accounts Committee.
And I believe that's coming through Public Accounts to us pretty soon, from what I read today in an email that we received. With that said, the action plan and moving forward with it, the time frame you suspect will be how long?
We can double check and see what some of the timeframes are that they have in their action plan. So they've got, related to, our first recommendation, which Transport Canada should provide regular public updates on the status of its regulatory plans. In fact, their expected final completion date for that was April 2017. Okay, there's another one here on our second recommendation that is September 2017. So in fact, another one January 2017, which they say is completed, one October 2017. So some of these are either, the dates have passed or are soon coming up. So, at this point, it's not just a matter of what they're saying they're going to do. They should be able to tell you, whether they have done what they had in their action plan, because many of the dates are in the past, in fact.
And I would anticipate that there will be or may be opportunity to attach itself to what we discussed earlier with respect to those new technologies and the regulatory environment keeping up with those new technologies.
Well, again, I think, the thing about an audit is in the course of an audit, we have findings, we identify things that need to be improved, we make recommendations, the department agrees with our recommendations, responds to them, prepares an action plan. And all of those individual activities is important, but I think it's more important perhaps to keep the big picture in mind.
Exactly.
Which is, are all of the changes being made lining up the regulatory system with what's happening in the industry, properly balancing sort of the safety and the economic and other considerations. So, I think sort of, again, as you keep an eye on this issue, it's not just sort of has the department done the individual steps that it said it was going to do. It's more, can they demonstrate that it is leading to a more efficient and more responsive regulatory system?
Thank you very much, Mr. Ferguson. On to Monsieur Aubin.
Merci, Madame la Présidente. Merci, Monsieur Ferguson.
Thank you, Madam Chair, and thank you, Mr. Ferguson and members of your team for being here with us. Your testimony was quite enlightening, and I was wondering, when the minister was before us, whether all the measures being proposed were more of an exercise in catching up than a real proactive exercise, and I think we're getting a clear answer to that. I'd like to hear you on a part of your last audit where you said that Transport Canada did not in a timely manner develop car safety standards to deal with emerging risks. We know that Bill S2 will give the minister powers to exempt manufacturers from certain regulations. So I'd like to understand this. Could we end up in a situation where there might be a better technology unaccessible to us, such as the headlight technology you were talking about? Or are we really dealing with a road safety problem which is not being addressed because tests are not being carried out by Transport Canada? In your audit, are you saying we're depriving ourselves of better technology, or are we not being as safe as we could be? I believe that, generally speaking, we have pointed to certain situations where better technologies are out there, but the regulations do not allow us to approve those technologies. And certainly, yes, it can be an issue of safety for Canadians. But perhaps my colleague here can add a few words. The headlights is a good example of what you're describing. That technology is out there. It's in Europe, but it's forbidden or prohibited both in Canada and in the U.S. Why? Well, there are several reasons, but basically, it's because there is a resistance from the RCC committee because that project has not been approved for regulation. In S2, as we said earlier, we do have flexibility by giving the minister the power to grant an exemption and to introduce vehicles on the Canadian market which don't meet standards, and those headlights don't meet Canadian standards. So S2 might, because the devil is in the details, S2 might therefore make it easier to introduce better technologies onto the Canadian market, which is just not possible right now under current regulations. Would I be wrong to state that if Americans agreed to adopting that technology, Canada would follow suit, but Canada would never be first out the gate? Well, let me just say that Transport Canada is looking at those headlights. The technical argument is that there are concerns with the blinding effect these lights might have. The technology is out there in Europe, but people might say, well, it's driving is different in Europe. The roads are either larger or narrower, so what works there might not work here. And there's also the matter of U.S. regulation, which at this point here does not allow that technology. Thank you. To any of you, some choices have been questioned by some issues have been questioned by the Department of Transportation. The investment of $5.4 million at the testing center for a certain technology, a certain device, and some people have questioned your investment of that $5.4 million.
Sure. Le problème était que
the problem is that they decided to build this device, which cost $5.4 million, while at the same time cutting funding for research, as the budget had gone from $1 million to much, much more. So we were wondering whether we should build this rail or slide or runner. So we questioned whether the money was spent in the right place. Now we're being told that Transport Canada is changing its approach to risk management. So I think that following cuts of over 50%, will new money be invested in bringing back testing, either in a controlled environment or in bringing back the regional teams on the ground who collect hard data and evidence to help us assess risks? Well, it's not up to us to decide whether money is being well spent or not, whether we're spending money on the right projects. It's up to the department to decide that, whether we're talking about $492 million or $1 million. I'm not really focusing on the amount. All I care about is the safety of the public. Well, that slide or rail or runner is useful. In Blainville, it was considered as being important. The reason why we're making that point is because there is a contradiction here. $5.4 million was invested, but there was no money to do follow-up testing.
Mr. Iacono.
Merci d'être là aujourd'hui.
Thank you for being there today. In your fall of 2016 report on your chapter on the safety of motor vehicles, you pointed to the fact that Canada is very slow at passing regulations on vehicle safety. In your opinion, why is Transport Canada so slow in this area?
And I think part of what we particularly pointed out was the fact that the department seemed to wait to see what the U.S. was going to do. That was, a significant part of the delay. Also, sort of again, the way that they were approaching the consultations, and they were, working, with the industry in terms of the consultations. And we felt that sort of their research program was taking a long time. So, I think there were a number of factors, but I think it was all perhaps focused on the fact that they first started with waiting to see what the U.S. was going to do.
You also spoke to the lack of data on collisions and injuries, since the government cannot force the provinces and territories to share data in a timely manner. What can the federal government do to fix that problem? Well, I think it's a matter of sitting down with the provinces to reach some kind of agreement to transfer that data to the federal government. So Bill S2 gives more powers to Transport Canada inspectors by giving them the power to collect data. In your opinion, will this help address the lack of collision data? Well, in the course of the audit, we did not specifically study the power of inspectors to collect collision data, but there was the matter of the 6 regional offices whose mandate was to go to the site of an accident to collect data and to speak to the coroner's office, to doctors, and to the police. In our report, we say that the funding for these regional offices, and actually these aren't regional offices, they are research centers at universities like in Waterloo and in Montreal, and that cutting that funding could imperil the collection of data on the ground. Now, as for the inspectors themselves and the work they do, we didn't look at that specifically. In your opinion, will S2, which will force manufacturers to provide more data on vehicle safety, will the bill help to improve vehicle safety? When we conduct an audit, our mission is to audit past events. We don't speculate on whether changes will be made, or we don't speculate whether change will actually take place when a bill is passed. But in the audit you're referring to, we did make recommendations with regard to the power of the minister to obtain more information from car manufacturers. We might have to work a bit longer to do another audit to determine whether the changes that were brought about will have had an effect. Thank you. I'll now share my time.
Very much. You do have the response from Transport Canada to some of your recommendations, particularly around the delay in developing new regulations. In the course of doing your audit, did you observed that it appeared as though they were trying to make sure that they were synchronized with NHTSA, the National Highway Transportation Authority in the States. Is that what they told you, or was this an observation of yours?
As we did the audit, it became clearer and clearer that the role of the RCC was prevalent, that the need to synchronize the regulatory framework was the primary objective, that the trade issue was the primary objective. Some bureaucrats at Transport sort of questioned that because they said we're there for the safety and we're not there for promoting trade. So it became apparent to us that this issue of the need to harmonize with the U.S. was the primary objective.
Did you detect any potential complications if, in fact, we in Canada got out too far ahead of the United States with some of the regulations, especially given the fact that a vehicle manufactured in North America crosses the border any number of times before the final product rolls out. So obviously the whole issue of harmonization pretty much has to be top of mind.
And rightly so, because we're trading partners. You don't want to have a car produced in Oshawa that will be made for the U.S. and another set made for Canada. This being said, the only exception to the regulatory framework in Canada, vis-a-vis the U.S., is the daytime running light. This is the only exception you'll find right now. We noted the issue of the anchorage system for car seats. Transport decided not to act on this one for trade reasons. We're not questioning if this is the right or wrong answer. We're just saying there's a potential gap here between what's required for Canadians vis-a-vis what's required regarding trade. Thank you.
You're on to your own 6 minutes, by the
okay.
way. You're a minute into it, which means you still have 5.
Good heavens, I need an audit now.
Original.
Yes. Do you get the sense you looked at this group that actually, between the United States and Canada that talks about regulations, et cetera. Did you get the sense that the American equivalent of Transport Canada is also felt to be behind, not keeping up with new technology such as the one you cited from Europe on headlights?
I would say no, because even though it's a cooperative approach that we have with the U.S., and discussions do take place between both parties. So from that perspective, we think that the Americans are not complaining about the RCC.
But would the American manufacturers be complaining about NHTSA for simply being too slow in new regulations? Again, it speaks to the whole issue of trying to be harmonized.
We did not audit the Americans, so we don't know exactly what happens there, but we know that there's a lot of pressure not to allow some technology in the U.S. for competitive reasons.
So again, that goes back to the comment that you made about trade perhaps being one of the motivators for a delay on Transport Canada's behalf?
One could see it that way, yes.
Did you look into any connection between, if you like, consumer protection and safety? You see occasionally where a manufacturer gets in trouble for having, a transmission that doesn't work very well, requiring a lot of trips back to the dealership and very difficult to repair. And I wonder if you looked at situations where the line between a consumer issue and a safety issue, it's a very narrow line. Did that factor at all into your audit in terms of Transport Canada's relationship with the other agencies that do oversee the auto manufacturing industry?
Madam Chair, I think one of the things that we identified in the audit that Transport Canada was in fact doing quite well was overseeing defects and recalls. So that whole area of the consumer protection and when a vehicle isn't living up to standards, I think they were managing well. Again, we identified that the department didn't have access to some information from the manufacturers, so that there are some things that they should be able to get more information about. But actually they were doing a good job on the recall and defect side of things. I think, again, going back in terms of the issue of, the U.S. and, the regulations, obviously there is an interest in trying to keep those regulations sort of as close as possible. But I think all of that just needs to be well-defined and designed within the regulatory framework in Canada. You know, how much of an influence is there going to be in the U.S.? Again, you know, the types of issues we raised, the fact that they were waiting for the U.S., I think are symptoms that resulted in the bigger problem, which was that it was taking Canada 10 years to put in place a regulation, okay? So when you have a system that is taking 10 years to put in place a regulation, I think sort of that's the indicator that the department really needs to be working on. Going back, they need to figure out, well, okay, if we want to be able to react more quickly, you know, how do we do that in terms of also being able to stay in line with the U.S., right? So the issue isn't so much whether they should or shouldn't be trying to stay aligned with the U.S. The issue is more, you know, how is that taken into account in the whole regulatory system? Is that a goal? Is that sort of the primary goal? If so, let's state it, and let's figure out then how Canadian regulations are set afterwards. So I think it's more about just sort of having clarity around that issue, you know, than saying they should or shouldn't be doing it.
All right, thank you.
Ms. Block?
Thank you very much, Madam Chair, and I join my colleagues in welcoming you here today. I did have the opportunity to sit in on the Public Accounts Committee where you were in attendance and spoke to the recommendations that were made in this audit. I guess I want to take a step back and look at the process around not only your audit, but the creation of this bill, and perhaps try and understand how the role of, what role the work that you do does or may play on the legislative process that we as parliamentarians find ourselves in. And I know it's been noted that this bill originated in the previous parliament as C-62, and was introduced in June, I think, of 2015, but that S-2 actually was introduced in the Senate in May of 2016. It was then referred to the Standing Senate Committee on Transport and Communications in October of 2016, and perhaps this is where you could correct me if I'm wrong, is you had actually I guess, initiated this audit in the fall of 2015? Is that when this audit was initiated? So the fall of 2015, you initiated an audit. We see this piece of legislation coming to the Senate in the form of S2 in the spring of 2016. So you're in the middle of your audit at this point in time. It then passes third reading in the Senate in February of 2017, but by now S2 has been introduced. I guess what I'm looking at is I'm wondering is there a missed opportunity here in the fact that you had initiated an audit, and then this legislation was introduced while you were in the middle of the audit? And do you have any role to play in terms of perhaps providing some advice to legislators as to whether or not it might be a good idea to wait until an audit is complete before you begin a process around introducing a piece of legislation that could look very different if we had the report in front of us?
So, you know, when we do audits, we walk into many different situations. Sometimes, in fact, we will walk into a situation where, you know, a department will tell us, look, we're working on something, please wait until we've done that and come back and do the audit after we've implemented. We hear that a number of times. You know, and then also situations where, yes, our audit results could have an effect on you know, the changes that people want to bring forward. sometimes our audits will help to spur something along, right? So a department may have been working on something, but it may have been sort of put on a back burner. We come in and we do an audit on a situation, and that sort of spurs them to to get it completed. So we walk into a number of different situations. Fundamentally, though, it's not our job to try to set policy or try to, say when policy should be changed or legislation or any of those types of things. So what we do is, we decide what topics we want to audit, when we want to audit them, and we go in and do that. I mean, occasionally we will change our audit schedule if we feel like the department is in a particularly significant transformation period for that program, and that it makes more sense to come in after they've completed that. Occasionally we will do that, but usually we just keep going with our audit schedule, sort of no matter where things are. Sometimes they line up with sort of the legislative calendar, and sometimes they don't, but that's not really something that we take into account or that we try to influence.
Is there a prescribed length of time that it takes for you to conduct an audit? Do you know going in how much time you have to complete the audit?
Our normal planning period really is from the time we, officially say, yes, we are doing this audit until we get it tabled in Parliament, is usually 18 months. Now, if we scope an audit down so that it's only looking at one item, and and if the area isn't overly complex, we can do audits more quickly than that. But these types of performance audits, we have to make sure, first of all, that we understand the topic area, right? So building up our knowledge of business on the area takes some time, making sure that we have the time to talk to all of the people that we need to talk to, getting the advice that we need to get, going through multiple iterations of draft reports with the department to make sure that we haven't gotten any facts wrong. All of that usually takes us about 18 months from beginning to end.
So you did note that it is not your role to form policy. I guess I'm wondering if you believe there is room for the work you do to inform policy after the fact. And I would suggest, as a parliamentarian, I think in a perfect world, I might have waited until your audit was complete on this specific area to see if there was anything in that report that would have fit well into this piece of legislation. I suppose we do have the opportunity to amend the legislation now, having been able to look at the recommendations that you've made. But I guess that would just be one observation I make.
Mr. Ferguson, I'm sorry, we're way over time here. Maybe you can figure out how to tag that answer in somewhere else. Okay. Or else, if you really think it's imperative, then we'll have to find a minute for you. Mr. Fraser.
Thanks very much. One of the big takeaways from your testimony for me today was essentially the timeliness of our ability to draft regulations, or implement regulations rather, particularly when we've got such focus on trade and harmonization with the U.S. I think you've laid out the problem very well. One of the things that I find I'm still trying to search for mentally is how do we overcome that barrier? Is this simply going to be a direction by the Minister to say, Transport Canada, forget what's going on with the RCC, forget what's going on in the U.S. You have the information to enhance safety through these regulations, just do it? Or what's the sort of obstacles that we're facing to do this in a more expeditious manner?
The obstacles, I think, in this are formidable. The things that the department needs to balance, I think, are there are very serious competing interests in all of this. So, again, I go back to sort of the starting point of, when issues are identified and it takes 10 years to put a regulation in place, that sounds like a system that isn't completely working. When technology particularly is changing as fast as this technology changes, when you have regulations that will deal with the types of lights on a vehicle, but nothing that says anything sort of about, some of the semi-autonomous and autonomous software that allows cars to operate with less driver intervention. It makes you at least wonder whether the regulatory system sort of is complete and robust enough. So I start more with, sort of what that end result looks like, and say, what the department needs to figure out is, what this regulatory system should be doing. So again, the types of things they need to consider, like I said, are formidable. What's going on in the U.S.? Do we need to harmonize with the U.S.? What's the impact on trade? What's the impact on the cost of a vehicle? What's the impact on the environment of having regulations or not having regulations? So, how much research do they need to have before they bring in a regulation? So there are a number of things that they need to sort out within that regulatory framework. But again, it seems to me that right now, the regulatory framework is one that just cannot keep pace with the rate of change. So I think, the fundamental question is the regulatory system that is, or the way they are operating the system right now, is it achieving what it was intended to achieve?
So if we, I think in very, very broad strokes, what I'm thinking what a framework should do is sort of keep pace with technology, improve safety when the information is there or is attainable. Go get the information and make the regulations really as quick as you can to affect the change that you're hoping to affect. I'm still sort of struggling. How do we do that? Do we need to, through Transport Canada, do a survey of all the places that we're behind right now? Do we need to be prioritizing research to get there, or am I getting into the realm of policy, which is really beyond your role as an auditor?
Well, in terms of all of the details of that, that's really something I think that Transport needs to sort out, right? They need to sort out what would an efficient regulatory system look like, what is it intended to achieve. So sort of getting down into that level of detail, I think, is beyond my knowledge and expertise. But again, I think fundamentally, when you look at the results of the audit, it's one that causes you to question whether, the regulatory system really is one that is, doing what it should be doing.
Most of the report is really not specifically tied to S2, of course, but there's one item that you mentioned today that I saw in the report as well that I do think is fairly applicable. And good news, I guess, for the safety of Canadians. You highlighted that we're actually pretty good at identifying defects and discussing plans with manufacturers. It seems that that's not a bottleneck in the system right now. With the new power to order recalls in S2, do you think, given that we're half decent at this, the minister's going to have all the information that she or he needs to order recalls that do pose safety risks to Canadians?
Well, again, I'm always very careful as an auditor that, what we audit is something, there has to be something we can actually audit, right? Okay. So as opposed to sort of speculating whether a change will or will not deal with it. But I think I
can rephrase and say, did you find any cause for concern in your audit that suggested there wouldn't be full information for the minister to identify these defects and potentially make an order to?
Well, certainly. I mean, we found instances where, as I think I mentioned, where manufacturers were investigating potential defects and the department didn't know about it. We found instances where the Canadian subsidiary didn't know that the American parent was investigating potential defects in vehicles. So, yes, there was, we identified situations where Transport Canada, didn't have access to all of the information, and we felt should have more ability to get access to some of that information.
Thank you very much, Mr. Ferguson. On to Mr. Chong.
Thank you, Madam Chair. Thank you, Mr. Ferguson, for appearing in front of us. I want to focus on the emergence of autonomous driving technologies and vehicles. I'm very worried that we're going to miss the boat as a country on what is a very important industry in our country. The auto manufacturing sector is incredibly important to employment in southwestern Ontario. It's one of our key industries, and I've been reading reports that the autonomous driverless industry could be worth up to $100 billion in about a decade in North America. And it seems to me that one of the big risks preventing us from being a big part of that is that our regulatory framework is not keeping up. We already have autonomous vehicles on the highways today. A Mercedes S-Class can drive itself down the 401, come to a complete stop in stop-and-go traffic, can accelerate up to 200 kilometers an hour, all without the driver touching the brake or the accelerator. It can steer itself down the highway. It can steer itself indefinitely, but they haven't turned that on, but it will steer itself for a period of time before, alarms start going off. So this technology is already here, and we don't have a clear regulatory framework on how to proceed. And you've identified this in your report of a year ago, that this was a big gap in the department's regulatory approach. You've mentioned numerous times here that there are lengthy delays to implement regulations and standards, sometimes in excess of 10 years. You've also, in your report of a year ago, said there are already semi-autonomous vehicles on the roads back then. And in your report, the department responded to your recommendation 4.35, a recommendation that says that Transport Canada should provide regular public updates on the status of its regulatory plans. The department committed to delivering on that last April. And we just had the minister here, and we were unable to get a clear answer as to when the new regulatory framework for autonomous vehicles is going to be released by Transport Canada. So it seems to me they're not even meeting the commitments that they made to you for the gaps that you identified in your report. So I just make that as a point. We're losing time here. 10 years is not that far out, and this is a critically important industry to workers and companies in Ontario. That's just a comment. If the Auditor General has maybe a comment in response to that, it would be appreciated. But there's a sense of urgency here, and I don't sense from the department and from the minister that we're getting that urgency back in return.
Well, I think, Madam Chair, that, again, really the important message, I think, coming out of this audit in terms of the regulatory system is that there is a regulatory system, or there was at the point of time that we looked at it, a regulatory system that was going at one pace and an industry that was going at another pace. And I think for the government to make sure that the regulatory system is relevant, it needs to make sure that that regulatory system can keep up with the pace of the industry, the pace of the innovation in that industry. And, again, we've identified a number of gaps, and we identified a number of places where, that regulatory process was taking too long. So I think that is the real challenge for the department, is getting a regulatory system that is keeping pace with the industry and figuring out how to get that regulatory system quite quickly.
Ban.
Merci, Madame la Présidente. J'aimerais revenir sur un élément de...
I would like to come back to something in your opening statement which troubled me. You said that we also noted that Transport Canada did not plan or fund its research activities or regulation activities in the long term. We're not talking about catching up, we're talking about the long term. So the department did not decide on how it would use its resources based on priorities. In these 7 recommendations you made, is there one specifically which addresses that problem? This is paragraph 9 of your opening statement. It's paragraph 63. Transport Canada should develop an operational long-term plan for the general direction of vehicles, including a budget and level of resources required to fulfill its mandate. I think what's important here is for the department to have a plan, a budget, and activities or priorities which have been defined. This way, the department can direct its activities over the long term. All of these elements should be contained in the plan. Yes, this has to be consistent. I have the impression that the department is making it up as it goes along. In paragraph 8 of your opening statement, you say that, and we're coming back to the anchorage strength issue, it is clear that the department chose trade over security. Is there a connection between this example and the disproportionate influence of the car manufacturers in the consultations? It's not quite sure what the role of car manufacturers were in the fact that the department was resistant at the time to regulate the anchorage strength in passenger vehicles. It was an issue of labeling on car seats, and we did not talk about other issues such as tires and other accessories. The anchorage strength, that's part of the body of the car. So regulations, the regulations applied more to the car seats for children, and that these car seats had to be properly anchored.
Thanks very much. We appreciate you taking the time to come and answer the questions. So if we could excuse the witnesses. So I will suspend momentarily. We have a short bit of committee business to do. At least I hope it will be short. What do we have to talk about?
Thank you.